All right, class. I want to believe you can see the slide. Can I have a confirmation, please?
Yes, sir. We can see the slides, sir.
Oh, all right. Okay. So this section of the course for this semester we deal with application of media materials. And basically that is legal research. So straight away, we're going to run through all of that for a couple of weeks, and then we should be done with this session. So, okay. So, by virtue of the slide we have on display, we start by talking about what legal research is all about. And we must state clearly at this point that legal research is one of the foundational skills that you, as a law student, must know or must have or must master early in your academic journey. And that is because of the importance of legal research to the profession that you are coming in. So therefore, the ability to conduct research is not only essential for your academic excellence, but also a professional necessity in the legal field. So, meaning that before an individual can successfully navigate through this field or practice as a legal practitioner, he or she must have the requisite knowledge, interest, and zeal to learn or to have mastery of legal research. So for every law student, legal research is key. And as you progress in your journey here, you will discover that indeed the knowledge is needed. And by the way, by the time you get to 400 level, you will take you to another level of legal research. So that shows the importance of the subject legal research. So whether you are going to be drafting legal opinions, whether you're going to be advising your clients or writing legal articles or preparing for argument in court, this skill will be required of you because it's not practically possible for you to have everything in your brain, but by or through research, you are able to know where what is or what you need is. So therefore, lawyers and as well as law students will rely on research to support their position with sound legal reasoning. And that because that's what law is all about. For example, you have been asked a legal question in the course of the examination. It is expected that while providing your submissions, there is this requirement on your part to back up such submissions with appropriate authorities, whether case law or statutory authorities, because that is a major distinction between you who is a lawyer or a law student and a layman who practically does not know so much about the business of law. So consequently, you need the knowledge in doing appropriate research to be able to generate an opinion that will suit the purpose for which it is being generated. Clients will at every point in time requires advice. Advice are not to be given based on your shared knowledge, because there are some advice that will require you to know a particular position of law. For instance, if I'm to provide an advice to a client in marine law, I need to have the requisite knowledge of the laws that govern marine operations in Nigeria. So, if I have not engaged in research, I won't be able to deliver on that assignment, as it is being said that Nemo dat cord not abet, meaning you cannot give what you do not have. So therefore, it is important for students to understand what legal research is and why it matters, and at the same time, how to effectively deal with legal research. Yes, you identify that you need legal research to be able to mature your point and back your legal reasoning with appropriate positions. So, even so, when you are engaging in an examination, or when you are writing an essay, or when you are to present an argument before the court of law, even in real life situations where there are legal problems, your opinion will be required. Consequently, the importance of legal research cannot be overemphasized. So the question, therefore, will be, what is legal research? We need to ask ourselves that question, which will give us the needed foundation we need to proceed on this journey. Hello? I hope you can hear me now. I noticed that
We can
I
hear
was
you
off.
now, sir.
We can hear you, sir.
All right. So, key definition that we need to consider, number one, is what is research? Because it's important for us to be able to provide adequate definition which will provide or give us the necessary foundation on the subject matter. So generally speaking, research can be defined as systematic investigation towards the sum of human knowledge as a process of identifying and investigating a fact or a problem with a view to acquiring an insight into it or finding appropriate solution to it. From the slide, you can see or identify keywords that have been itemized. Now, we see the word systemic there, systemic investigation. Now, meaning that legal research embraces procedures, meaning that legal research requires step-by-step approach. And what is the purpose of research? Is to increase the sum of human knowledge about a particular subject or a process, and or to discover many things about a fact or about a particular problem which requires that a solution be provided for. So, in general terms, we've seen what research is all about. So, there can be medical research, there can be legal research, there can be research in practically every areas of life. So, but what is our focus in this class is legal research. And then the question, therefore, that we need to ask ourselves is, what is legal research? Okay? What is legal research? Then again, I need to mention that research as a subject has so many definitions so that we don't box ourselves into a corner by saying that, oh, the definition that our lecturer gave us is, all in all of the definition of research. That will not be correct. So we submit by virtue of this class that research had so many definitions. Now, even when we look at the Webster International Dictionary, research was also explained to mean a careful critical inquiry or explanation in seeking facts or principles. It went further to say diligent investigation in order to ascertain something. So that's the way the Webster International Dictionary define the word or the subject research, that it is a careful, critical inquiry. Of course, this is not different from the definition that we have advanced in the slide that is before us this morning, which talks about the fact that research is usually systematic. And I did explain that will cover or require that a particular procedure must be followed. Then, therefore, the Webster Dictionary then is not out of place. And of course, like it mentioned there, that is a careful critical inquiry or explanation in seeking fact or principles or diligent investigation in order to ascertain something. So the purpose of research is to provide a solution to an issue, which can be anything whatsoever. Therefore, we'll ask, or we look at, the definition we are provided here. Then let's move on to look at what legal research is all about. So legal research refers to the process of locating the legal rules that apply to a particular issue. Okay? Legal research refers to the process of locating the legal rules that apply to a particular issue, interpreting those rules, and applying them to the facts of a case or a legal problem. That's what legal research is all about. So, simply put, legal research is locating legal rules that helps to resolve particular issues. To this extent, we can say, therefore, that it involves searching for legal authorities. Okay? Legal authorities that include primary sources or secondary sources, as the case may be. Okay? So, basically, legal research refers to that process of locating the legal rules that apply to a particular issue, interpreting those rules, and applying them to the fact of a case or a legal problem. And I went further to say that it involves searching for legal authorities, including maybe primary sources, such which covers subject materials like the Constitution, for example, the Constitution of the Federal Republic of Nigeria. It also involves statutes, case law, and treaties. All of these, fall under the what we refer to as primary sources. So, again, it can also include secondary sources. Hello?
We can hear you, sir.
All right. Okay, so we're talking about primary sources and secondary sources. I said secondary sources will include sources like Constitution, statutes, case law, and treaties. While on the other hand, we talk about secondary sources, we refer to textbooks, academic articles, legal dictionaries, and encyclopedia. So, therefore, this will give us an idea of what legal research is all about. Now, let me throw the floor open by way of exercise, that if a student is given an assignment on freedom of expression in Nigeria, for example, what should or what constitutes the problem, what should be the approach to the problem, and how can the problem be solved? Now, I'll yield the floor to the class for contribution. That, for example, I want to define what legal research is. Now, you have an assignment to talk about freedom of expression in Nigeria. What will your legal research include? Can I have contribution? And please, if you are not speaking to us, kindly mute your mic so that you don't disrupt the class. Can I have contributions, please? No one is willing to speak?
Sir, we can't hear the question right, sir. We can't hear the question right, sir.
Okay, I said, for example, if you are asked to talk about freedom of expression in Nigeria, what are the issues that you are going to look at, and what will your research involve? That's my question. No one is willing to speak? All right.
Good afternoon.
Yes, please. Go ahead. Onola, all right? Uriola.
Okay, so if I'm to talk about freedom of expression in the Nigerian context, I'll first start by stating the legal validity of freedom of expression, which is in Section 35 in the 1999 Constitution. Then after then, I'll now go on to look for international sources like the United Nations, UDHR, the Africa Charter, then I'll look at freedom of expression within the scope of Nigeria.
Okay. Yeah, that's a good attempt. Yes, who else? Or what else?
Good morning, sir.
Good morning.
Yeah, so in looking at this question or the topic that you just gave us, yeah, what I would do, the way I would approach this is first coming from the fact that the Constitution of Nigeria, that is Chapter 4, provides for certain rights that we call the fundamental rights. Then
Okay.
moving directly to the specific right you mentioned, which is the freedom of expression. Then, according
Okay.
to what the previous person said, you will state the provisions of those rights. Where can we see that freedom of expression has been guaranteed? And looking at it directly in the Nigerian scope will come from the Nigerian Constitution and the direct provision in Chapter 4. Then we can also look at other treaties, as he has said, the UN, UDHR, the African Charter of Human and People's Rights. Then now you'd now explain the provisions and also look at the exceptions to the freedom of expression. Then now you will now come to what actually is, where we see that freedom of expression has been realized or has been breached. And I think we'll be gravitating towards case law in that extent. So we'll look at cases where we can see where people have contested the breach to their freedom of expression, and we can see what the judges have decided, what was the reasoning for the decision. We can also see if freedom of expression has really been realized in Nigeria. For example, we can go to the extent of talking about maybe demonstrations, protests, and how we see how the government has reacted to people actually expressing their freedom of expression. Then you will just conclude that maybe giving maybe some opinions about what you think on that freedom, if it has been really realized in Nigeria, or what we think can be made or as improvements to actually ensure that that freedom is actually realized for the Nigerian citizens.
Okay. Beautiful. Thank you very much. The two contributors did justice to the question that I've asked. Now, I agree with you. And as a matter of fact, you were able to highlight the key points on the subject, which, to a large extent suggests that you understand, what it is to do a research. Now, let's approach this together, even though, in our own little way for the purpose of this class. Number one thing you need to do, just like was suggested, is the provision of Nigerian law that talks or that provides for freedom of expression. Where is it located? Of course, your research will probably take you to Section 39 of the Constitution of the Federal Republic of Nigeria, which categorically provides, and I quote, he said, "Every person shall be entitled to freedom of expression, including freedom to hold opinion and to receive and impart ideas and information without interference or any form of interference." That is the position of the Constitution of the Federal Republic of Nigeria on the subject. As a matter of fact, which is the number one law that governs the subject that we are to research into. Then you may consider looking at case law that have dealt with this issue, and one that comes to mind is in the case of Director of SSS versus Olisa Agbakoba. This was a case that was reported in 1999, and of course, the court of law did justice in trying to determine whether or not the right of Olisa Agbakoba to freedom of expression has been violated. Of course, you know who Olisa Agbakoba is, a human rights activist and a lawyer here in Nigeria. So, of course, the issue that was before the court, because you cannot just talk about provide a case without necessarily giving the fact or try to know the ratio for the decision and other things that transpire within, the proceedings. So the question here was whether the action of the SSS in stopping Olisa Agbakoba from traveling abroad to express his view infringe upon his constitutional right to freedom of expression under that section 39 that we have, itemized. In this case, Olisa Agbakoba was, scheduled to speak on democracy and human rights, outside this country, but he was prevented from embarking on that journey. And then, it landed in court, and the court had to interpret or to provide details of what Section 39 is all about. And if you are doing this kind of a research, you've been able to provide the law, provide a case law, more like a practical demonstration of the law that you have identified. What this does to you is that it shows how knowledgeable you are on the subject. So, in this case that we're talking about, which your research ought to, deal with, at least by stating some specific items as discussed by the court. The court spoke about the broad scope of Section 39 and interpreted freedom of expression to include not just the right to express one's view within Nigeria, but also the right to reveal, to receive, and impart information and even ideas across or outside Nigeria. That's one of the position that the court had in that case. Also, the court also held that Section 39 protects a citizen's right to speak at an international gathering, which supports the earlier position that the court, made by saying that this right to freedom of expression, does not end within the four walls of Nigeria as a nation. Also, if the court went further to talk about limit on governmental powers, he said the court emphasized that national security concern must be balanced against fundamental rights, one of which is the one we are looking at, which is the right to freedom of expression. And the court maintained that the SSS cannot arbitrarily infringe on constitutional rights under the guise of national security. And of course, if you are able to speak to all of this in your submission, then you will have been providing solution to the subject that you want to address. In that same case, the court talks about limit on governmental powers, meaning that the government cannot arbitrarily infringe on the rights of citizens. Then freedom of movement is also connected to this particular provision, or to this particular, yes, this particular right as enshrined in the Constitution of our land. So, in all, the court ruled that the action of the SSS in preventing Olisa Agbakova on embarking in his journey violates his right to freedom of expression. In that case, what the court did was to expand the interpretation of Section 39, which include international expression, not just speech within Nigeria. Now, one of the things you will have noticed in the course of my submission is that outside what you know the freedom of expression to be, the process of researching or going through, available material to drive home the point as further, enlarge, or as further broaden our understanding about the concept. And of course, if you are to deliver a paper or make a presentation and you're able to mature your point in line with all that we have been saying, you will have at least been able to drive home your point. So then, outside looking at case law, you can also consider reviewing scholarly journals on the same issue, meaning that your effort is not limited to the Constitution of Nigeria, neither is it limited to case law, but there are other scholarly submissions that must have been done in this regard, and this will provide further information that can enrich your knowledge on the subject. So therefore, you see that what legal research has been able to do is to enable you to consult available materials with the purpose of explaining what the freedom of expression is, as in this case study that we have looked at. Well, of course, it has succeeded in also informing those who may care to listen as to what freedom of expression is. So that's, in summary, or for short, can explain what we mean by legal research. Moving forward, therefore, we ask ourselves, why is legal research important? Why do we need to deal with legal research as a subject? At least at your level, we need to have the why for legal research. You need to know the why for legal research. And as itemized on the slide before us, legal research can be carried out for different reasons. Okay? Number one, which I'm going to talk on briefly, is understanding the law. As you progress in your academic journey in this university, there will be call for the need for you to understand the law. In understanding the law, you will need to carry out extensive research, because understanding the law does not deal with a particular provision of law. There are laws that one way or the other will become connected, in the course of your research. So, and that is because laws are not always straightforward. And we need legal research to help us to clarify what law is, how it applies, and how it has been interpreted by the courts. I'm sure that one of the topics that you have considered in the course of your journey so far will be what is law. And you may not be able to find a suitable definition at this time as to what law is. And I can assure you, because I know that what is law is also part of other courses that will still come before you, even when you get to 200 level. And for the direct entry students that are here, you will recall that we dealt with that extensively in some of the topics that we have dealt with under the Nigerian legal system. And I can assure you also, when you get to your final year, the question will still be put to you as to what is law. So legal research helps to clarify what the law is, because that is the base of any legal activity. And then how the law applies, even the procedure, the process of the lawmaking, and how the court must have applied it. Also, even the various canons of interpretation or of rules of interpretation that may have been engaged in interpreting the law. All of these, forms part of the reason why legal research is necessary. So that's number one. Number two reason. Hello, class. I want to believe you can hear me clearly.
Yes, sir.
All right. So number two reason is building legal arguments. That is another reason for legal research. For those who have had the opportunity to visit our courts, you notice, you observe that every litigant who has approached the court for one thing or the other always believe that they have a right, always believe that they have a good case, always believe that they can explore the law in their favor. But before any individual can succeed on any question of law within a court, the individual needs to build an argument that is capable of making the court to rule in their favor. The reason is because the court is not Father Christmas. The court does not work by emotion and cannot be moved to decide a particular subject, by emotion. So, therefore, before the court can find for an individual or can rule in favor of an individual, the individual must have done proper homework as it relates to building arguments that will make the court to find in their favor. So, what therefore an individual needs to win an argument or win a case is that he must be able to provide relevant legal authorities to back up his arguments. So, research allows them to find and cite these authorities. Now, I give you a practical example of a particular matter that we were involved in recently. It has to do with a case of between landlord and tenants. And then what was the issue in this case was the fact that the landlord had informed the tenant that she needs possession of her place. But under the Lagos State tenancy law, it is required that for a landlord to take possession of such property, there are requirements for statutory notices that must be issued. And not just issued, it must be appropriately issued in compliance with the law, in compliance with the requirements on statutory notices. So we were for the claimant in this case, and then the defendant, who happens to be the tenant, challenged us that we did not serve one of these, we did not serve quit notice on them. And in court, making such a statement or an assertion or trying to win such argument require that you lay sufficient authority to support whatever you are saying. And we argued forth and back up to the point that we had to write an address regarding that. And what gave us victory there was that, of course, we made reference to various provisions of law, and we referred to a particular case because their argument was that since we did not serve, then the court lacks the jurisdiction to hear and determine the case. And then what we did in our own way is to also research and get an authority that speaks to the fact that even if a tenant has not been served with the compulsory statutory notice, that in the case of Odutola versus Paper Sack, the court did mention that yes, the law does not encourage the landlord not to issue the required statutory notices, but where such was not done, that once the tenant has been served with the processes indicating that the landlord wants possession, then that constitutes a valid notice of some sort. We won that case on that strength. And that was because, number one, the matter has been in court for almost 3 years. So if you are in court for 3 years, you are fighting that they didn't give you 6 months notice, but you have been in court dragging that issue for 3 years. The law believes that it is unfair for such a tenant to continue to enjoy under the guise that statutory notices was not served. Now you have had notice for 3 years. What stops you from giving up possession? But the truth of the matter is that if you are unable to provide such an argument, the court may not find for you. How do you prefer such an argument? It is simply by or through legal research. We move to number 3. To explore an unknown area. The era we are is a time where knowledge is available even at fingertips. Consequently, even without having knowledge on a particular area, an individual can research, can dig deep to have specific information, needed information on a particular subject. So, And in this our case, law is constantly evolving. Each day, new cases come up, new statutes, and even interpretation emerge regularly. Research ensures that students and practitioners are aware of the current state of the law. If you know the law as pertains part performance in law of contracts, and then the law you have was the one that was enacted sometime maybe 1970, and a case law that was decided in 1975, and that's what you are still holding on to. You'll be shocked to know that there are new interpretations that may have been given to such judicial authorities that existed then. So what research does for us, or why research, is that it helps us to stay informed, that is, to explore an unknown area. Number 4, as we can see there, is for academic performance. Recently, I was grading some scripts, and we're talking about issues pertaining to the historical development of common law and equity in Nigeria. And then we come across students who were brilliant enough to cite relevant cases to back up their arguments. Those students cannot have the same score or grade with those who wrote essays without backing up with necessary statutory provisions or laws. So, one of the reasons for research is for academic performance. As a matter of fact, if you also want to deploy an article, you want to write an article to inform the society or to develop a particular area of law, you are duty bound to research, because it is in research that you are able to provide, the needed information, which is to enhance academic growth or knowledge development. The 5th one we are going to look at is professional responsibility. Now, one of the things that we need to note is that clients expect accurate legal advice. And I'm sure that one of the things you will come across when you begin to practice is that with just a page document, page legal opinion, you can earn millions of naira with just a page. So, but the page must be so loaded with the needed authority to back up what is needed. So therefore, one needs to research so that you can be able to meet professional responsibilities. Another one we can see on our slide is to clarify an issue. Even the courts are also faced with their primary duties of interpreting the law. How will the court successfully discharge this duty? The court can successfully discharge this duty only through adequate research. That's why when you read past judgments by renowned jurists in this country, you get carried away by their erudite submission, because they were able to back up their judgments with appropriate legal authorities. Look at judgment written by Lord Oputa, Karibi White, Ways, name them. You'll see, proper submission where cases are used to clarify issues, or even scholarly work in different areas are used to clarify issues. Another reason why legal research is important is to prove a set of circumstances. As a matter of fact, when you are engaging in your legal argument in court, it is either to establish a circumstance or a fact in issue, or to disprove a particular fact in issue. So it can be needed to prove a set of circumstances, at the same time to disprove a set of circumstances. So with so much or few of the reasons that we have itemized, you will know therefore that legal research is a must for you as a law student, and also even when you eventually become a practitioner. So with that, we move to the next subtopic, which is a critical question on how to conduct legal research. Okay, but before then, let's look at the different types of legal research that we have before we talk about how we can conduct legal research. We have qualitative, quantitative, descriptive or analytical, applied or pure research, conceptual or empirical. So also we have doctrinal and non-doctrinal research. So the assignment you have is that you look up the meaning of all of these types of research that we have. Of course, by the time you read them up, you understand these different types. I do not want to overburden you with dealing with them one after the other, so that it doesn't get complicated for you. So, but of course, read it on your own at your leisure time. You will understand have a basic knowledge or understanding about them. Okay, someone who wants to ask a question. I saw someone indicating any questions so far before we move to the next topic, which is how to conduct legal research. And that brings about the how that is involved in legal research. Now, legal research is more than just googling. It requires a methodological approach. It requires that you follow a particular procedure. It requires that you understand what you want to do before embarking on it. Generally speaking, I will speak to what we have on the slide on how do we carry out legal research. Before engaging on any legal research at all, it is important to know some specific steps that the research process or procedure requires. As you can see there, number one, you have to design your research questions. The main question and the sub questions. These are things that are already within your knowledge, but the journey is how to achieve it. Oh, you know that you need to do library research. You need to do internet research. You need to do note taking. Even sometimes you conduct interviews before you can adequately, begin your research properly. Sometimes you have to do case reporting. You know how to do
Let me
the
keep plugging
outline.
to my phone on. Let me keep connect to my phone network. This one is faster.
Okay? So you do the outlining because all of these are the basic foundation that you need to lay, because you cannot embark on a journey without adequate preparation. So therefore, number one, as we have listed there, before we take, I'll teach you, the various steps that are involved, but all of these are so fundamental. Because before you can embark on such journey, you need to know what you want to do. If it is a case you want to defend a suit or you want to file a suit, there are questions that you need to ask yourself. And then, of course, when embarking on the preliminaries of trying to formulate your thoughts on how to proceed, you definitely need to be armed with those things. So now we look at specific steps on how to conduct research. Number one step is that, just like we mentioned earlier, understand the legal issue or question. Yes, somebody wants to ask a question, please go ahead. Hello? Somebody wants, okay, no one? All right. So you need to understand the legal issues involved. Let's look at the case study we consider. Freedom of expression in Nigeria. What is the legal issue? The legal issue has to do, of course, it can be generated in various forms. It's number one, what is freedom of expression? What does it connote? What does violation of same amount to? Or what problem does it generate? You need to understand these issues. And then, of course, your questions will also move along the line of what amounts to freedom of expression. What guarantees freedom of expression? What can make our amount to violation of freedom of expression? And so on and so forth. Then step two is to identify the area of law. Of course, like in this instant case, we talk about constitutional law, because of course they deal basically with issues that pertains to the constitution of the public generally. Excuse me. Then also, still talking about step one, just by way of just to digress a little. you need to identify keywords, legal terms, and facts. Ask yourself exactly what is the question. If, for example, you have to look at breach of contract, then the question then therefore is that what are the basic elements of a valid contract, or what even constitute a contract, or what even constitute a breach, and the applicable remedies and so on. All of these questions must come as part of the foundation to what is to be dealt with. Then let me move to to identify the area of law. Identifying the area of law is to classify the legal issue, whether it's a criminal law matter, or constitutional, contract, or tort. And because this helps to narrow down the sources to consult. You cannot be doing a research on constitutional law and then you are consulting economic textbooks or other areas of endeavor that may have a link with it. But the challenge is that they may not provide, they may approach the issues in different views, not necessarily the area of law that is an issue. So you need to identify the area of law. The number 3 steps is that start with secondary sources. That is, you use secondary materials to gain background understanding. If you are going to embark on this kind of journey, you need understanding. Look at your textbooks, Nigerian constitutional law, that by S.A. Malemi, and so on, their likes. You look at legal encyclopedias, look at journals in articles or articles in journal, and all of that. All of this gives us or provides the requisite foundation knowledge or understanding that we need to have about the subject. Because before you can embark on a research, you need to have a thorough understanding of the subject. Not having a thorough understanding of the subject will not give you room to do proper justice to the subject in issue. So it's important because the secondary sources will explain principles, we even give you examples and then point you in the direction to embrace. Number 4 is find primary legal sources. Because once you have understood the legal principle, you need to find the actual legal text. Look at your statutes, that criminal code, electoral act, whichever one. Also, you look at your cases, your case law. When you talk about Donoghue versus Stevenson as it relates to negligence, you look at Oyewumi and Co. relating to definition of customary law, and so on and so forth. What about the Constitution? Especially when it relates to fundamental rights and the likes. Then, even the law reports in Nigeria also serve this purpose. And in today's world, we already have different legal databases that include the likes of the Law Pavilion, Legalpedia, and several other platforms that can be deployed for legal research. So find primary legal sources. Number 5 step is analyze and interpret the law. Don't just read laws and cases. Understand their meaning and their implications. Even sometimes you go to the point of comparing these decisions in these cases. Are they conflicting or are they consistent? If the case laws are not consistent, then it calls for concern, which must also be reflected in the work that is being being done.
Question, sir.
Yes, please go ahead.
Right. In the case of, because we're talking about consistency in law, which is, well, we'll probably look at the Constitution being the grand law, as the case may be. Right. In the judgment that was delivered by Abia versus FG, right, where it was delivered that the local government can actually take the funds from the federal accounts directly right now. I mean, I think there's a conflict between the Constitution and the judgment of the Supreme Court at that instance. In a scenario like that, what do we follow? Is it the Constitution or the judgment of the Supreme Court?
I think you still need to study that report, because reading a report goes beyond just reading the probably the decisions. There may be need for you to. It is difficult for the Supreme Court to go against the Constitution, because number one, the Constitution has set up the Supreme Court, and the scope of power of the court is also contained there. But I do not want to agree, though, because I've not read the authority you're talking about. I may not be able to say, but usually, even if the Supreme Court has reached such a decision in error, the Supreme Court, by virtue of its power and position, can overrule itself in subsequent cases if such is brought to the notice of the courts. Is that taken? All right. I believe that is taken. I move on to apply the law to the problem. That is essential. Because once you have gathered relevant legal authority and you apply them to facts, then you will be able to organize your argument. All of this will help you to drive home your point. Number 7, record and reference sources properly. Any legal research without adequate referencing may be a kind of waste of time. Okay? So, therefore, you need to identify your sources to avoid plagiarism and all of that. And then, just to add to what we've been talking about, there are basic legal research skills that you also need to have, okay, which include reading and comprehension, because it will be difficult completely for you to do an appropriate research if you fail to read, if you don't understand what is put before you, or you are unable to understand the tenet, everything within it, there will be issue. Number 2 is note-taking and summarizing. Okay, note-taking and summarizing. You need, as you read, you need to jot down key points, because of course the brain may not be able to carry all of it, so you need to note down Then you need to learn to summarize your judgment into the main issues, itemize or determine the ratio, and then, and all of that. Then, citation and referencing is very key, and then use of legal tools and resources. So then, also, what are the common challenges that you can face as a beginner? You see, you can have difficulty understanding legal terminologies, but of course, there is no crime in that, but eventually you will still get there, in that with consistent practice and consistency, you will understand. Then information overload. Sometimes you gather a lot of materials, you do not now know which one to use or to apply. It happens, every now and then, but as you make progress in your academic journey, you will be able to sieve, the needed or the less needed, the most needed, and so on and so forth. Then sometimes they consult on verified sources. It can, or bring out an entire activity down. Then lack of guidance in research, you cannot know it all, especially at this your stage. But these are common challenges that have been identified. Lastly, tips for effective legal research. They are not limited to the 5 that we have listed. They include: be curious. Don't just stop at one source. Explore multiple viewpoints. This will make your research to be very rich. Also, be methodological. We've said that research involves procedural steps. It is only when you follow those steps that you can arrive at the right destination. Then, one of the ways you can be good at it is when you practice regularly. Also, working with others can also enhance effective legal research. And then usage of current materials will only expose you to the current position of law, and nothing more, nothing less. In conclusion, on this particular topic, legal research is the backbone of legal education and practice. I want you to know that. And as young students or those who are just starting to learn the law, the earlier you develop your research skills, the more confident and competent you will become throughout your legal education. Because when you are taking any course relating to legal research in future now, you will not be treated as if you are just getting to know it. So you will be expected to have the basic knowledge, because legal research is not just about finding the law. It is about understanding, interpreting, and applying it accurately. The submission of Aristotle is there. He said the law is reason, free from passion. But for you to find that reason, you must first know how to research the law. Okay? These are valuable submissions that we need to know. Okay? So having said that, we'll bring this class to a close at this stage. And I don't know if you have a question. We can take that before we call it a day here. Okay? Any question? Is it well understood? Hello, class. I believe it is well understood. All right. So I will say
Yes,
that.
yes.
Yes, I do.